1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်420ဒေါ်ဝင်းကြည် N1 applicants vs M.A.L CHETTIAR fan and 1 respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Application before ဦးကျော်ဆန်ဦး and ဦးစိန်သင်း Judges ဒေါ်ဝင်းကြည် and 1 applicants vs M.A.L CHETTIAR fan and 1 respondents Union Judiciary Act Section 6 Law of Limitation whether explanation for delay presenting the application necessary, admission after the period of limitation on sufficient cause. Hell, there is no dispute that the application is grossly barred by the law of limitation. The excess of 343 days must be explained by the applicants. They must give an explanation for every day that they delay, which merely means that they must give some reasonable explanation why they did not pursue their remedy within time. Refusal to explain would defeat the rights which have become vested on the other party. Lady Raj Malik and another vest, Dr. Susan Dasan, AIR 1951, Simla 209 refer to under Section 5 of the Limitation Act. However, the application may be admitted after the period of limitation if the applicant satisfied the court that he had sufficient cause for the delay. What constitutes sufficient cause cannot be laid down by hard and fast rules. There is no universal formula. It must be determined by a reference to the circumstances of each particular case. The discretion given to the court under the session should be exercised on its own facts with a view to secure furtherance of justice based on judicial principle and not arbitrarily. In exercising discretion, the court must consider whether the applicants have acted with reasonable diligence. S.M.L. vs. Mang San Nyei, ILR 14 Run 155 refer to. There is no bar under Section 6 of the Union Judiciary Act to file an application for special leave to appeal within 90 days under Article 179 of the Limitation Act against the judgment and decree passed by 3 judges of the Chief Court, Daw Shwe Sein Mya vs. U Thun Aung Pru, and 1 FB, being Civil Miscellaneous Application Number 14 of 1965 of Chief Court explained. Ula Pei 2 for Dr. Bahan for the applicants, Mr. G.N. Banerjee for the respondent number 1, U An Jaw and U Tan Aung for the respondent number 2, U Jaw San U Judge. This is an application under Section 6 of the Union Judiciary Act for special leave to appeal against the judgment and decree passed on 19 September 1964 by 3 judges of this court in Civil Miscellaneous Appeal number 40 of 1963. The parties agreed before us that the date of presentation of the application, which is not very clear from the entries made in the proceeding by the office, should be fixed as 13 December 1965. that is, 460 days after the date of the judgment and decree, and 127 days spent on copying as calculated by the office are excluded. The application was presented 433 days after the date of the judgment and decree, though the law allows only 90 days under Article 179 of the Limitation Act, within which to present the application from the date of the decree. The applicants in their affidavits also affirm that the application was presented to the court on 13 December 1965. There is no dispute that the application is grossly barred by the law of limitation. The excess of 343 days must be explained by the applicants. They must give an explanation for every day that they delay, which merely means that they must give some reasonable explanation why they did not pursue their remedy within time. Refusal to explain would defeat the rights which have become vested on the other party. Lady Raj Malik and another vest, Dr. Susanta San Wan. Under Section 5 of the Limitation Act, however, the application may be admitted after the period of limitation if the applicant satisfies the court that he had sufficient cause for the delay. What constitutes sufficient cause cannot be laid down by hard and fast rules. There is no universal formula. It must be determined by a reference to the circumstances of each particular case. The discretion given to the court under the section should be exercised on its own facts with a view to secure furtherance of justice based on judicial principle and not arbitrarily. In exercising discretion, the court must consider whether the applicants have acted with reasonable diligence, as M.A.L vs. Mounsanye 2 under subclause 2 of Section 14 of the Limitation Act. So far as this application is concerned, only the time spent on prosecuting another proceeding with due diligence against the respondents for the same relief in good faith in the original court or in the Court of Appeal, which, from defect of jurisdiction or other cause of a like nature, is unable to entertain it, can be excluded. This subclause has no application here, as the sufficient cause set forth in the affidavits in support of the application is that the applicant's advocate, Dr. Bahan, the doyen of the Rangoon Bar, landed only on 23 November 1965 of the decision of the full bench of this court, date 10 August 1965, in Civil Miscellaneous Application Number 14 of 1965, Daw Shui Sain Mya vs. U Thun Aung Pru and 1, that he could find an appeal under Section 6 of the Union Judiciary Act against the judgment and decree passed by 3 judges, and that the applicants themselves came to know of it the next day, and yet they were not diligent enough to find this application for special leave within a reasonable time, but waited till 13 December 1965. Under Article 179 of the Limitation Act, time begins to run from the day of the decree appeal from and not from the date of knowledge of the right of appeal. the full bench decision in Civil Miscellaneous Application number 14 of 1965 was passed so long ago as 10 August 1965, that is, 125 days before the filing of the present application. Dr. Bahan did not appear before us, so we do not have the pleasure of knowing from him personally whether he really came to know of the right to appeal only on 23 November 1965. That is over 105 days after the passing of the judgment in the full bench case. As a matter of fact, there is no bar at all under Section 6 of the Union Judiciary Act as substituted by the Union Judiciary Act Amending Law 1962, being the Union of Burma Revolutionary Council Law number 41 of 1962, to an application for special leave to appeal against the judgment and decree passed by 3 judges. The word "any," which appears at 3 places in the section, is very significant. It says special leave may be granted to appeal from any judgment or decree in any case of any court, even including a court constituted by 1 or 2 judges. At most, it can be said is that the section is not properly worded. The applicants could have filed this application for special leave to appeal under Section 6 of the Union Judiciary Act within 90 days from the day of the decree, that is, 19 September 1964, under Article 179 of the Limitation Act. It may be of interest to quote the relevant extract from the judgment in Civil Miscellaneous Application number 14 of 1965 of the full bench of which one of us was a member. သာမန်အားဖြင့်တရားသူကြီး2ဦးသာထိုင်၍ကြားနာစစ်ဆေးလေ့ရှိသောအယူခံမှုမျိုးတွင်တရားသူကြီး3ဦးပါဝင်သောအဖွဲ့ကကြားနာဆုံးဖြတ်ခဲ့လျက်ပြည်ထောင်စုတရားစီရင်ရေးဥပဒေပုံမှန်6အရာအထူးအယူခံဝင်ခွင့်တောင်းဆိုနိုင်ခြင်းမရှိပြီဟု၍လည်းဆုံးဖြတ်ထားခဲ့သည်မဟုတ်ချေယခုပညာရှိရှေ့နေကြီးဦးဘရွှန်ကဒေါ်ရွှေစိန်မြ၏ရှောက်လွှာပေါ်မှဤပြဿနာကိုဖော်ထုတ်တင်ပြ၍သာကျွန်ုပ်တို့အနေနှင့်စဉ်းစားဆုံးဖြတ်ပေးရခြင်းဖြစ်သည် It is clear from the judgment that the applicants cannot take refuge in it. Their explanation for the great delay is utterly unreasonable and unsound. We were informed that an application to review the judgment now sought to appeal against was also filed on 19 November 1964 before the filing of the present application, but it is still pending. If we may say so, the applicants put out a double-edged claim, a rather unusual claim to review the judgment as well as to appeal against the same. The full bench decision does not upset the existing law on the point in any way. It merely confirms the meaning it conveys. In the result, the application fails and is dismissed with cost, advocate fee, Jet 68 for respondent number 1.